Good morning, this is your Kelso Report for Thursday, November 10th, and I'm your host, Clark Kelso. To say there has been confusion about the scope and legal effect of California's Compassionate Use Act and medical marijuana program is an understatement. What the initiative and resulting state statutes have successfully done, however, is to give the courts, the press, and the public a great civics lesson in the complexities of living in a federated governance scheme where different layers of government, local, regional, state, and national, sometimes issue overlapping and conflicting laws, and different branches of government react in different ways to implementation of those laws. In today's featured case, City of Riverside versus Inland Empire Patients Health and Wellness Center, the conflict plays out in the context of an ordinance enacted by the City of Riverside that banned medical marijuana dispensaries throughout the city. After the ordinance was enacted, the city enforced it through the mechanism of a public nuisance action, where the city sought a preliminary injunction enjoining a dispensary from operating within city boundaries. The legal issue presented was whether the local ordinance was preempted by either the Compassionate Use Act, which was enacted by an initiative measure, or by the medical marijuana program, which was the legislature's effort to implement the initiative. The trial court granted the city's request for a preliminary injunction, concluding that there was no preemption. The 4th District affirmed. The state law dealing with preemption is straightforward. 3 types of conflicts give rise to state law preemption. First, a local law that duplicates state law. Second, local law that contradicts state law. And third, local law that enters an area fully occupied by state law, either expressly or by legislative implication. Now, absent any clear indication of legislative intent, when local law deals with an area over which local government traditionally has exercised control, there is a presumption against preemption. Applying these simple principles to the Compassionate Use Act and medical marijuana program was equally straightforward for the court. Neither the act nor the program contained any clear indication of preemptive intent. So the analysis begins with a presumption that the city's zoning ordinance was not preempted. Next, neither the act nor the program fully occupied the field of law dealing with marijuana use and regulation. To the contrary, both were drafted very narrowly to target only the issue of whether medicinal use of marijuana or production for medicinal use was a defense to a criminal charge under state law. As the 4th District said, the act, quote, provides a limited defense from prosecution for cultivation and possession of marijuana. The act is narrow in scope, close quote. It is already clear that the act did not protect cultivator or possessors from prosecution under federal law. And because the act is narrowly focused on a defense to state law prosecution, it was equally clear to the 4th District that the act did not displace local land use and zoning regulations. There is nothing at all necessarily inconsistent with a state law that establishes a narrow defense to certain state marijuana prosecutions, with a zoning ordinance that prohibits businesses from selling marijuana within city limits. Accordingly, the 4th District held that, quote, Riverside zoning ordinance does not duplicate, contradict, or occupy the field of state law legalizing medical marijuana, close quote. Now, the result in this case is obvious, as is the result in cases holding that the state initiative does not protect users or cultivators from prosecution under federal law. Supporters of the Compassionate Use Act have no legal justification whatsoever for being surprised at these results. The act was sold to the public on the basis that it did not create rights and was not tantamount to legalization. The courts are simply following through with that limited promise. And now our one-liners for today. We only have 3. The first in the area of civil procedure and the law of preclusion. In Beets versus County of Los Angeles, the 2nd District held that the trial court improperly sustained the defendant's demur to a wrongful death complaint, alleging that a police officer had unlawfully used deadly force in apprehending the decedent. The demur was based on the fact that a jury had convicted a co-participant in the incident of assaulting the officer who used deadly force on the decedent. The defendants argued that in light of this conviction, the wrongful death action must be dismissed, because if the wrongful death action were successful, it would necessarily imply the invalidity of that criminal conviction. Now, in Yount v. City of Sacramento, the California Supreme Court in 2008 did hold that a battery claim brought against the city arising out of an arrest had to be dismissed, given that the plaintiff had been convicted of the underlying offense for which the plaintiff was arrested. The court reasoned that the tort suit could not proceed if its success would necessarily imply the invalidity of the underlying conviction. But in yesterday's case, a key difference was the person convicted was a co-participant in the incident and was not the person who was shot and killed and the plaintiff in the case. Because of this difference, the Second District held that Yount did not apply, and the wrongful death lawsuit was therefore not barred by the co-participant's conviction. Restating the holding in civil procedure terms, collateral estoppel did not apply because the plaintiff was not a party in the prior criminal case and was not in privity with a party to that case. Next, an evidence law case in Karen P. v. Superior Court. The Second District granted a writ of mandate directing the trial court to vacate its order denying a motion to quash, a subpoena ducis tecum, on the ground that the patient-litigant exception vitiated the child's physician-patient privilege. The child, a young girl, had disclosed to authorities allegations of sexual abuse by her father and had submitted to a forensic medical examination. The Department of Children and Family Services then filed a dependency petition under Section 300 of the Welfare and Institutions Code. The father sought the child's medical records by subpoena, and the Superior Court rejected a motion to quash, citing the patient-litigant exception to the patient-physician privilege. That exception applies when a patient tenders in litigation an issue concerning the patient's medical condition. The Second District held the patient-litigant exception did not apply here because the girl had never herself tendered in litigation an issue concerning her medical condition. Her disclosure to authorities and submission to a forensic examination happened prior to any litigation, and the department's filing of a Section 300 dependency petition was not done on her behalf, so she did not herself tender an issue about her medical condition to the court. Indeed, the child is a party in her own right in the dependency hearing, and her interests are separately represented. Accordingly, the child's physician-patient privilege was not extinguished by virtue of the filing of the dependency petition. Finally, government law case involving open meetings. In Service Employees International Union versus Options, a child care and human services agency, the Second District held that a government contractor, which promised in its contracts to comply with the terms of the Brown Act, that's the local government version of the open meetings laws, it was going to comply with the Brown Act in meetings of its board of directors to the extent that such meetings involved publicly funded programs. The court held that government contractor could be sued by a member of the public for injunctive relief to enforce the contract's open meetings requirement. The Second District held that all members of the public were third-party beneficiaries of the contract's open meeting terms, and therefore had standing to sue for injunctive relief to enforce the open meetings requirements. Now, the court also held that the government contractor cannot be sued directly under the Brown Act itself, since the contractor is not a legislative body as defined in the Act. So in summary, although there was no basis for suing under the Brown Act itself, a member of the public can sue to enforce its rights as a third-party beneficiary of the government contract. I think it's going to be very interesting to see how a private corporation and a private business operates when its board of directors is forced to meet in public just like a government board. Should be quite a sight. And that's it for today's Kelso Report. Have a great day in the law.